and welcome to the Cook County Bar Association's Live on CAN TV. Today I will be your host. My name is Mika Thompson, and our guest today will be Attorney Kenneth Carr. Hello.
I'm fine.
We will be discussing probate. So if you have any questions regarding probate, please call the number that appears at the bottom of your screen. That is 312-738-1060. The Cook County Bar Association takes this time at 6 p.m. on Tuesday nights to discuss issues of legal import to the Chicagoland community. Please note you can always watch this show on the internet, www.cantv.org/live. As you may or may not know, the Cook County Bar Association is the oldest association of African American lawyers and judges in the United States. Although I am an attorney and Attorney Carr is an attorney, we do not represent your interests. So we always encourage our viewers that are watching on TV or streaming in to go to the Cook County Bar Association's website. You can find it at www.cookcountybarassociation.com. You go to lawyer referral and scroll down, and you will find a list of attorneys that are licensed and in good standing in the state of Illinois and their practice areas, their contact information. So you can call them, and some even place their email addresses. Okay? Otherwise, you can go to the Cook County Bar Association and call us by phone. Contact us at 312-630-1157, extension 21. And a staff member at the Cook County Bar Association will answer your call and give you the information to one of our lawyers who are a member of the Cook County Bar Association. Now, Kenneth Carr, will you take a moment and introduce yourself to our viewing audience?
Yes, my name is Kenneth Carr. I have about 10 years of experience as an attorney. I focus primarily in estate planning and probate administration, or estate administration, which many people call probate. I deal a little bit with guardianship issues as well as small business transactional matters. In general, I'm somewhat of a general practitioner, but I focus mainly on estate planning and estate administration.
Great. So we have a great and excellent attorney here who is very, very competent and knowledgeable in the area of probate law. I also practice in probate law, and again, I'll be the host and I'll be asking the questions. But before we begin our discussion, I just want to remind you that the Cook County Bar Association and its board members and its officers and its members and sponsors do not particularly, we must inform you that the opinions and views expressed on the show do not necessarily reflect the opinions of the Cook County Bar Association, its board members, its officers, and its members and its sponsors. So now we can begin our conversation. The first question that I wanted to ask Attorney Carr is to give a definition of probate to the listening viewers.
Okay, great. Well, again, I'm glad to be here. Probate is essentially a court-ordered process that allows the distribution of a person's estate, actually their property, after they have died. And generally speaking, unfortunately we all die, but how we distribute our property after death either can be under our control or under the control of the courts. And usually, if you want to put it under your control, it's better to have a will. And if you don't have a will, then you're basically defaulting to the rules of the state, the government, to get involved. But even with the will, that allows you to have the control over how you distribute your assets, but still that's also a court process. If you want to avoid having to go through probate, then you want to identify what we call non-probate assets, which are assets that are titled in terms of have beneficiaries that are someone else other than your estate. For example, life insurance, where you have beneficiaries that would go to the beneficiaries instead of to your estate. So let me just back up for a minute. So when a person dies, their property goes to their estate. So when John Doe dies, after John Doe dies, we now refer to John Doe as the estate of John Doe. So all the property that's in the estate of John Doe is considered probate property. This is property that has been titled in John Doe's name and has not been, it hasn't been titled to other beneficiaries. So it'll be up to either the executor or the administrator to then manage the estate of John Doe to make sure it's distributed properly according to the rules of Illinois.
Okay. And for clarification purposes, the probate system here in Illinois does not just specifically govern deceased people, correct?
Oh, that's true. I mean, we also deal with guardianships, which is another big area. Mm-hmm. And guardianships, there's actually two parts. There's guardianships for minors, and then also guardianships for disabled adults. So those are that's another area that's a big aspect of the probate caseload.
So you were talking about the administrators and the executors. Can you give the viewers an understanding of who are the basic parties in a probate case? Particularly, let's start with the decedent's estate, the division of the probate process that pertains to the dead people.
Okay, so we really don't refer to them as the dead person. We refer to them as a decedent. Okay. Well, you used that term. I was just going to follow it up. But the decedent is really the person who died, and we really look at it in terms of two cases. Did the decedent have a will? And if they did, then it's called they died testate, which means they died with the will. If they died without having a will, then they died intestate. And so there's two different paths. They're similar, but there's two different paths. So if there is a will, then we will follow the process with the will. There's usually an administrator, not necessarily administrator, there's an executor who's normally defined in the will, who will then carry out the wishes of the will. Now, if a person died and they didn't have a will, then we'll have what we call an we'll have an administrator. And the administrator's role is similar to the executor, except that the administrator will be someone who petitions to take over and manage the estate and distribute the property on behalf of the decedent.
And that administration is in accordance with the law then.
Of course, exactly. Both administrations are carried out in accordance with the law. There's Illinois law, and there's also law particular to the county. So we're in Cook County, so Cook County may have additional rules that may need to be followed. So in addition to the executor or the administrator, hopefully there'll be an attorney involved to help guide the process, and the attorney will be responsible for making sure that the legal aspects of the state are being followed and the rules and procedures and timelines for the court order processes are followed, and then also to make sure that the estate is being handled in the best interest of the beneficiaries. So the beneficiaries are another party, and the beneficiaries could be heirs or also legatees. So,
right. And so the heirs are the ones that are designated in accordance with the law versus in a will. The will could specify anybody they want.
That's correct. And then if it's a will, the people who were, who will receive property under the guidance of a will are considered legatees. Those, and if you don't have a will, then you're basically saying, state of Illinois, Cook County, I'm basically leaving it up to you to distribute my property. And then the property will be distributed according to what we call the orders of descent. And so, for example, if John Doe is married and has 2 children, when John Doe dies, half the property will go to the spouse, and then the other half will go to the children. And so those are considered the heirs if John Doe did not have a will. Now that may sound fine, but let's just say that there is a case where there's a fallout with one of the children. The children are adults, and the John Doe did not intend for any of the children to have any property under the will. Have any property in this case, but since John Doe didn't have a will, they will receive property anyway because he didn't specify that in a will.
Right, and it's usually very significant when there's a pending divorce matter, correct?
That's correct. That's correct. So right now, if you really can't what we call exclude a spouse from receiving property. As long as they're as long as you're married, they have a right to property. whether it's specified in a will or not specified in a will. However, you can, in a will, disown or disinherit children. So that is possible.
Right. So it's very important that people take the time to make those designations while they're living, because it can be pretty serious. I have a case now, and it went to first cousins, and it's a lot of them. So it can get really serious, and just no way that this person intended for all these people to have anything. So it's just
right. And unfortunately, I mean, I won't say unfortunately, but I would just say in today's society we have a lot of blended marriages. We have children out of wedlock, and so there are a number of potential legatees or heirs that may come to the forefront when a person dies. You've seen the cases where a celebrity dies, then all of a sudden you have estranged wives, estranged girlfriends, unknown children coming forth looking for their share. And so this is where the estate planning part becomes very important. I mean, it's very important, if you can, to prepare a will so you can specify how your property will be distributed, upon your death.
Okay, so we've talked about the parties and a little bit regarding the process that is involved, whether it's a deceased person, whether it's a will or someone who dies without a will. What are the qualifications that a administrator or an executor must meet in order to be an administrator or an executor?
Well, you got to think about that role. That's a pretty serious role. They're going to be handling the money, the affairs, the property interests of the decedent, the person who died. So we have, the law says there's some high requirements. Well, first of all, they have to be at least 18 years old, of sound mind and body, not disabled, and U.S. citizen, and they can't be a felon. Unfortunately, the law frowns on people with convicted felonies taking on this role because of the money and property interests involved.
So what are those roles? What are they required to do? And is it different depending on whether the person is going to be an administrator or an executive?
Well, they're similar. Like I said, if they're an executor, they're going to be following the rules and the instructions in the will. So that's a little bit more straightforward. If it's if they don't have a will, then they'll have to divide the property, as I mentioned before, based on rules of intestacy. And again, depending on whether there was a spouse, whether there are children, and that will determine the percentage of their share. And then they'll have to then divide up the property based on those particular percentages. And then if you have, like I said, a spouse and 2 children, and let's say one of the children dies, and they're now and they had children before, then their share would go to their children. So it can be rather complicated depending on the amount of property that's involved. So the roles really is about collecting performing an inventory of all the assets, determining what's there, and then trying to inform the beneficiaries of this property, and then distributing that property in a timely manner after you've satisfied all claims against the estate, which is can be significant depending on the estate. There could be estate taxes due. There could be claims where there are bills that should have been paid over to the federal government, the state government. So there's a listing of order of preference for dealing with claims.
Okay, if you're just tuning in, this is the Cook County Bar Association's live on CAN TV show, and I am attorney Mika Thompson. I'm your host, and we're talking about probate with my esteemed colleague, Kenneth Carr. You can call us at 312-738-1060 and ask a question regarding probate. We'd love to hear from you. Okay, returning to our conversation. So when you're talking about claims, what about the house? What happens with that? I mean, who gets that, and how does that handle?
Well, it depends on how the house was titled. Mm-hmm. So if the house, again, you have John Doe and Jane Doe, they're married, and the deed to the house says John and Jane Doe as husband and wife, then the property automatically goes to Jane Doe, mm-hmm. and it stays out of probate. But let's just say that John Doe wasn't married.
Mm-hmm.
And so the property remains in his name only, so that becomes part of his estate. And so then who's ever the executor, the administrator, now has to take steps to transfer that property to either what are the instructions under the will or to the heirs. And this is where you get into an example where if you have multiple heirs, they may have to transfer, so they have different fractional shares.
Mm-hmm.
There could be 10 people and they each have a tenth of a share of this house or property. And so that can be more complicated, because once you transfer that ownership to those 10 people, you'll need to have their approval later on if they want to sell it.
Right.
And so that means you'll have to have agreement.
Right, but
So,
doesn't it, when we're talking about claims, doesn't it also matter if there's a mortgage on that property before?
well, that's true. That's true. If there's still a mortgage, it depends on how the mortgage was written,
Mm-hmm.
and if there's still a balance, if the property's underwater or not. It could be a matter of is it a candidate for foreclosure. So those are things you have to weigh with the lender, depending on if there's an issue where the lender wants to take the property back because there's monies due. But if they're in good standing
and somebody's willing to pay.
right, somebody's willing to pay, then you can discuss that with the beneficiaries and the heirs.
Right, because
So, right.
and how long is the claims period?
Well, when you start the probate process, again, you open a probate estate, and then that's basically opening the court case, and you get a case number. And then what you're supposed to do after that is file not necessarily file, but publish a claims notice in a local newspaper, and that's supposed to be for 3 consecutive weeks, and in a local newspaper, so that individuals can be aware that this probate estate is open. And then the claims period is open 6 months from that last date of the claims, the notice in the publication.
Okay, we have a caller. We'll come back to that issue. Caller, what is your question?
Yes, hello?
Yes,
Yes,
how are you?
I stepped out. I thought the gentleman was saying something about a convicted felon could not be an executive of an estate, of the estate or something like that. I mean, I wanted to get an understanding of that, and then I wanted to make a comment too.
Yeah, unfortunately that's true. If you have a conviction as a felon, you cannot serve as an executor or an administrator of an estate, and unfortunately that's just the law in Illinois, because again, you're dealing with property interests, financial interests, and right now the law frowns upon, unfortunately, felons assuming that role. So it doesn't mean that they can't support the administrator and help with the affairs. It's just that they can't officially be the administrator or the executor of the estate, which means the person.
What about this? If you have a person,
I'm sorry.
Say it again. We couldn't hear you.
I want to ask you, ask you a question and comment too. What I want to ask you a question or make a comment too. What about let's say a person is not passed away, and they have a person I think it's called a power attorney.
Okay.
Could a convicted felon do that, or what?
Well, that I think they could be. Well, I'm not sure about the power of attorney.
Well, the power of attorney is something that's executed by the living principal.
Right. He's just asking if a felon can serve in that role as an agent.
So whether or not the law will get involved in that, because that's an agreement between the two people. There's no process where the law is going to interfere with that unless there's been some malfeasance. If there's something, because again, this is an individual signing an agreement. He's passing the agreement on to his agent. If the agent actually has a felony on his record, there's really not going to be a way in which the court system or the police would get involved in that process unless the agent does something illegal or alerts,
Right.
Brings his conduct to the attention
Right.
of the court system.
So I'm not aware so I guess the short answer is it's not. I believe a felon can be
Right, because it's not, it's a discretionary decision between that person that's executing it and the other individual. Now, I do, and I'm sure a lot of attorneys advise, they counsel individuals to investigate a person's background before they execute a power of attorney and make sure that that person has a reputable character and have the qualifications to do whatever it is that they're authorizing them to do, because that power of attorney, in that agreement, you can turn over a lot of your rights to this third party, and banks, hospitals, school systems will look to that third party as having authority over your money, over your health care decisions. So that's a very serious thing to do without making sure that that person has the qualifications that you want. But it's really a decision that the person is making who's the authority, who's the principal, who's giving authority to their agent as to whether or not they want someone with a felony doing that job, being that agent. So, but as far as the law frowning on it, it I don't see how they would really get involved in it, because it's a personal decision. It's discretionary. It's discretionary for that individual. So.
Did we answer your question? I think we did. Okay.
Okay.
Okay. Well, just to clarify for our audience, the power of attorney, you probably have heard about that. There's a power of attorney for property, and this is really dealing with your financial affairs, your bank accounts, stocks and things of that nature, real estate. And then there's power of attorney for healthcare, someone to make healthcare decisions for you. And these are, the principal would give responsibility to an agent, which means a person who could step in their shoes to assume responsibility for the principal to make decisions on their behalf, because they are typically disabled. And that's why the principal is still alive, and they're allowing an agent to make these decisions. But again, who you choose as your agent should be done with care, because again, they can make life or death decisions for you from a health point of view, and also financial decisions for you.
Yes.
Okay.
Okay. So returning to the questions, what is the cost associated with performing for an attorney for administrator of an estate or executive of an estate to retain an attorney?
And the short answer, it depends. And because of that, everyone says, well, my case isn't that big of a deal. And my case is simple. And really, a lot of these cases aren't that simple. I would say if your estate is less than $100,000, you can probably have a small estate affidavit if somebody wants to take on that responsibility. And it's just a matter of the attorney reviewing that information with you, collecting, making sure you understand the scope of that document, and then completing it and notarizing it for you. But again, that's for estates under $100,000 that don't involve real estate. So that could be a more simpler process. But estates that are more that do involve real estate and personal property over $100,000.
Or children.
Or in children also, it could be more significant. And this is why you'll see attorneys usually charge an hourly rate, because they're not sure of what they're getting into. We're not sure what we're getting into.
Right.
And again, particularly if there's cases where you have heirs or beneficiaries who may be combative, they don't like what the terms of the wills are, or they don't like the share that they're getting under the rules of intestacy. They may want to challenge they may want to make challenges and file, get their own attorney. So it could be pretty involved. That's why an hourly rate is probably what we pursue.
Well, this concludes our show today. Attorney Carr, I'll let you have the last word.
Well, estate administration, probate is important to everyone. So I would say if you need the services of a competent attorney, I would recommend you contact the Cook County Bar Association or any other the bar associations in Chicago. The Cook County Bar Association is the oldest African American bar association in the country, so we would hope you would contact us first. But again, whoever you work with, make sure they're a competent licensed attorney, and at least for a consultation, to at least assess the landscape that you're facing. an initial consultation may not is worth the money just to get an overview of what you're facing.
Thank you, all of our viewers, and you have a good night.
Thank you.